Hello, I'm William Bloodworth II with the Bloodworth Law Firm. I'm also a grandparent. These are two of my grandchildren. In Texas, grandparents can gain court-ordered custody or access to their grandchildren. It is possible, but the legal requirements will be difficult to meet except in rare situations. A grandparent who petitions a court for custody or visitation must meet two legal requirements in order to win custody. First, the grandparent must establish what is called standing. Second, the grandparent must prove that the change in custody is in the child's best interest. In what situations will a grandparent have standing to file suit? The Texas Family Code provides three separate avenues of standing for grandparents. Number one, the general standing. The circumstances most often used for grandparent cases is a section that allows a suit for custody to be filed by any person who has had actual care, control, and possession of the child for at least 6 months, ending not more than 90 days preceding the date of the filing of the petition. This reason is most often used in cases where a grandparent has had possession of the child and has primarily raised the child. The second way is to establish a significant impairment. If a grandparent has not had exclusive possession for 6 months, a grandparent or other blood relative is allowed to file a custody suit if they can prove to the court that the child's present circumstances would significantly impair the child's physical health or emotional development. In other words, the grandparent's burden is to show that the child's parents are unfit. The third way is not really custody, but instead access. Texas has a grandparent's possession and access statute. In contrast to the above statutes that allow a grandparent to file a custody suit, a grandparent can file suit for only possession and access. In order for a grandparent to win under this rule and gain court-ordered visitation with their grandchild, a grandparent must prove, among other things, that denial to the grandparent of possession or access to their grandchild would significantly impair their grandchild's physical health or emotional well-being. This is a very difficult standard to meet. Why are the laws so restrictive on grandparents? Is this just a Texas thing? No. On June 5th, 2000, more than 16 years ago, the United States Supreme Court made a ruling in a case called Troxel versus Granville. In that case, the Supreme Court reaffirmed the principle that parents have a fundamental constitutional right to raise their children as they please, and that the state must not interfere except in extraordinary situations. Following that ruling, many states, including Texas, were forced to amend their grandparents' statutes, or at least tailor the law's application to comply with the Supreme Court's decision in the Troxel case. The Supreme Court stated that parents have a right to decide with whom their child will have contact. In other words, it's up to the parents to decide when, where, or how the children will be allowed to spend time with a grandparent. In fact, the parents may decide whether or not the child sees the grandparent at all. A parent's decision to exclude the grandparents from the child's life is unlikely by itself enough of a reason for a court to find significant impairment. Additional unique circumstances or serious signs of unfit parenting are usually necessary to improve the chances of a grandparent winning a possession and access case. Even if a grandparent wins a possession or access case, the amount of possession or access can range from a simple telephone access to possession in accordance with the Texas Standard Possession Order. This decision is entirely within the judge's judicial discretion to make. We at the Bloodworth Law Firm have represented both parents and grandparents on both sides of this issue. We have been victorious in obtaining custody and possession and access for grandparents, and also victorious in preventing grandparents and other relatives from obtaining access to grandchildren. We at the Bloodworth Law Firm are uniquely qualified to handle your grandparents' access case, whether you are seeking a grandparent's access only or you're a parent attempting to restrict such access. If you would like to consult with an attorney about your rights as a parent or grandparent, please call us. We are here to help you. I have been through a custody battle and I know what you feel like. It's important to have a strong and zealous advocate on your side.